everyone, and thank you for joining us today for a discussion on managing long-term rentals under the Executive Order, Emergency Directives, and the CARES Act. I'm Rachel Branson, the Professional Development Manager here at NC REALTORS, and I'm excited to join you all today. Before we get started, I'd like to let you all know that today's webinar is being recorded and that it will be made available after today's session. I've added the number for our tech helpline in the chat field, along with a link to our education roundup page that contains information on upcoming programming. You can reach out to the tech helpline at any point during today's session if you experience any technical difficulties. Please also know that you can submit any questions you have in the chat field at the bottom of your screen, and we'll do our very best at the end of today's session to address all of those questions. With that, I would like to introduce and to welcome my fantastic colleague and your PMD staff liaison, Amy Kemp.
Hey everybody, thank you for signing up and showing up today. I wish I could see your faces. I miss you all so much, and I hope this finds you and your families healthy and safe during this time. I want to thank all the PMD members who are here today, and if you aren't a member of PMD, you can join for $45 annually. I will put my email in the chat box so you can email me if you're interested and not currently a member. With that, I'm pleased to introduce your moderator for today, the 2020 PMD Chair, Jennifer Stoops. She is also the Executive Vice President with Park Avenue Properties in Charlotte, where she has direct oversight of all the firm's business. So thank you for being with us, Jennifer. I'm going to turn my camera off and let you take it from here.
Thank you so much, Amy and Rachel. Good morning, everybody. I am really excited to work with this incredible group of panelists that are going to bring an incredible amount of information for us. There's so much confusion that we have been enduring during this pandemic with executive orders and the CARES Act and moratoriums and what can we do and what can't we do. And so without further ado, I want to turn it over to our panelists. Today we have with us Will Martin, who is General Counsel at the North Carolina Realtor Association. We have Katie Thomas, who is our Chief Lobbyist at the North Carolina Realtor Association. And we have Fred Moreno, who is Chief Deputy Legal Counsel of the North Carolina Real Estate Commission. So thank you all for being with us. I know everybody has been asking all three of you a lot of questions, and so we'll get right into it. I know we've got a lot to cover and want to make sure we get everything in as much as possible. So what we're going to do is we're going to turn it over first to Fred Moreno. Fred, would you mind taking us through sort of, the information that is most pertinent to us with respect to the CARES Act?
Sure, absolutely. And thank you for having me here. I'm delighted to try to explain some of the federal law under the CARES Act. As many of you know, this was in response to a lot of the coronavirus pandemic. And really the sections you need to deal with in the CARES Act are Section 4023 and 4024. I'm going to start by talking a little bit about Section 4024, which deals with temporary moratorium on eviction filings. So the first question you need to ask yourself, again, we're looking at this specifically just from the federal level. You need to ask yourself, what kind of property am I managing or does my client have? If it is a covered property under the CARES Act, it'll be a property that is occupied by a tenant pursuant to a residential lease or without a lease or a lease terminable under state law. This covered property must also be participate either in the housing program, such as the Violence Against Women Act of 1994, or Rural Housing Voucher Program, or probably what it'll encompass the most people is a federally backed mortgage loan. So you want to see if that applies, then you are dealing with a covered property under the CARES Act. There can be a federally backed mortgage loan on a single family dwelling, or there could be a multi-family federally backed loan. And we're going to talk about the differences between those two as well. But if you have a federally backed mortgage loan, this would be considered a covered property under the Act. So what this Act then does is it creates a moratorium. This moratorium is for a 120-day period, which began on March 27th of 2020 and ended on July 24th of 2020. So during this moratorium, the Act states that the lessor, your landlord, or the property manager in this case, cannot file a legal action to recover possession in court. So you cannot file during that 120-day period. Number two, you cannot charge any fees, penalties, or other charges to the tenant relating to non-payment of rent during that 120-day period. Then you have to give notice. Once you are going to pursue an action for removal, you need to give a notice which must be for at least 30 days to vacate. You have to give a notice to vacate before you enter the legal proceeding. That notice to vacate cannot occur during the 120-day moratorium period. It has to start. The clock starts ticking on that when the tenant receives notice to vacate. So if you mail it, it may take a couple of days. If you go and hand deliver it, it's the day that it's delivered that they'd receive it. But the clock starts ticking, and it can only be served on or after July 24th of 2020, which would be the expiration of the 120-day moratorium period. So on a federal level, that's what you're looking at. People, you cannot charge late fees and that sort of thing between March 27th and July 24th. You cannot evict anybody. You cannot file legal proceedings. You cannot file notices to vacate during that 120-day period. It is only on or before after July 24th that you can then give the notice. You have 30 days. So what we're probably going to see is a lot of things happening the end of August and early September, with people then filing the legal proceedings after giving the 30-day notice beginning on or after July 24th. Now, I mentioned a little bit about that is the moratorium period for evictions. Again, when you're dealing with houses with a federally backed mortgage or dealing with the federal government. I mentioned earlier a difference between single family dwellings and multifamily dwellings backed by those mortgages. So section 4023 deals with what we call a forbearance of residential mortgage loan payments for multifamily properties with federally backed loans. So again, you're dealing with multifamily properties, multifamily federally backed loans. If your landlord owner has this type of loan, there's a little bit of a wrinkle here. That person has the ability to ask the federal government for forbearance on their mortgage. So now we're talking about the landlord being protected. Earlier, we're talking about the tenants and evictions, but now we're talking about the landlord. They're saying, hey, federal government, if my tenant's not able to pay because of COVID, I'm unable to create this income to pay on my mortgage. I would like a forbearance period where I do not have to pay on that mortgage or get any late fees or anything like that. So the government has allowed this specific subset of people to ask for that. And if they are granted, there is a forbearance period which they may ask for that. And that is, again, beginning March 27th until March 27th, 2020. But the kicker for this one is it's going to go until the termination, the sooner of the termination of the national emergency for COVID-19 or December 31st, 2020. Since we don't really see any end in sight for the president saying the pandemic is over, I would have just assumed December 31st, 2020 at this point until we hear otherwise. So now we have a forbearance period between March 27, 2020 and potentially December 31st, 2020. Within that period, the landlord can ask the government for a forbearance period of up to 30 days where they do not have to pay on their mortgage. If they are still having issues, they can ask for 2 more sets of 30 days for up to a total of 90-day window within that forbearance period. how does this impact tenants? Well, if the owner is, if there's a current forbearance period in place, the owner cannot evict a tenant, right? And that kind of makes sense because you can't have the owner getting relief from the federal government on not having to pay the mortgage and then turning around and kicking out a tenant for not paying on a mortgage. So if there's a forbearance period that is happening, then the notice, we go back to the notice, the 30-day notice still applies, but you cannot file that, or you cannot give that 30-day notice until the end of that forbearance period and the end of the moratorium, the 120 days that I talked about earlier. So there's two things in play possibly, and that's what you have to check with your landlords to see if they've asked for that forbearance and you're currently in that period. Once the forbearance period has expired and the moratorium has expired, then you can give the notice to vacate for 30 days. And then after those 30 days, you can pursue with the legal proceedings. That is sort of in a nutshell what these two sections do with the CARES Act. Again, this is specifically just on the federal level. Will talk to you a little bit more, I believe, about the state side of things.
Thank you so much, Fred. I know that's a lot to cover, and you took us through it very well, because I appreciate you breaking it down into terms that we can understand, because there's a lot going on there. If this, then that. And so thank you very, very much for taking us through that.
Sure.
So Will, we're going to come up to you next, if you don't mind. So not only have we been navigating through the CARES Act and everything Fred just took us through, but then we've also had to navigate through our own state orders. And so would you mind sharing with us some information, which I think, especially for us here in North Carolina, has really added an additional layer of complexity to try to figure out with Executive Order 142?
Sure, Jennifer, thank you. And good morning, everybody. The governor, I just counted a few minutes ago, it looks like he's issued 39 executive orders since March 10th. And one of them I want to touch on for just a few minutes. It's Executive Order 142. This was issued on May 30th on a Saturday, and it was the governor's own moratorium on evictions. The eviction moratorium prohibited any action to evict a residential tenant for non-payment of rent for a period of 3 weeks, which took it through June 20th. So it was a very short moratorium. We thought there was a good chance that it was going to be extended, but it was not. It elapsed on June 20th, and knock on wood, hopefully it won't be renewed again by the governor, but obviously we're in a very fluid situation here, so none of us knows what's going to happen for sure, but that moratorium was over on June 20th. But there are other aspects of it that remain with us and are relevant to evictions. The moratorium also prohibited the assessment of interest, late fees, or other penalties on residential tenants for non-payment or late payment of rent during the what they call the effective period. And the effective period was this 3-week period of time that the eviction moratorium was in effect. This was all residential tenancies, not the limited number that were covered by the federal law on federally backed mortgages or those that participated in some kind of a federally funded housing program. So this was all residential and commercial tenancies, as I'm going to cover in just a minute here. But so no late fees or other penalties for non-payment of or late payment of basically the June rent. Also, importantly, the governor's moratorium required that tenants be provided the opportunity to make reasonable payment arrangements to pay off over at least a 6-month period any rent that became due during the effective period and that was not paid during the effective period. So again, we're talking about June rent. So a tenant has the has to be given the opportunity to pay it off over a period of time. There was a similar moratorium put in place regarding commercial tenancies for non-payment of rent during the effective period. Unlike the residential tenant, the commercial tenant had to demonstrate that their late payment or non-payment of rent was caused by the COVID-19 pandemic. But other than that, it was, I think, virtually identical to the order as it pertained to residential tenancies, because it included the same limitations on the collection of late fees, interest, or other penalties, and provided commercial tenants the opportunity to pay off unpaid June rent for a period of 6 months. The last thing I'll say is that Executive Order 142 specifically states that it did not affect evictions for reasons other than late payment or non-payment of rent. So that's a quick thumbnail sketch of Executive Order 142.
Thank you so much, Will. That was really helpful. So the next thing that we're going to go to, or the next person we're going to go to, again, just trying to help bring clarity to everything that we've been dealing with. So Will, that was incredibly helpful, adding additional layer of information to sort of helping us navigate through all that's going on. We're going to open it up for Katie, who I'm quite sure was very busy over the weekend, and I know just in general has been incredibly busy with everything that's going on. But now we have some new news that came in over the weekend. So Katie, I'm going to turn it over to you to talk through a little bit about what may be coming that's kind of out there as potential. Not that we're trying to make anybody nervous, but we kind of, want to know what's going on. And of course, we had some news over the weekend that is very impactful as well. So without further ado, Katie, I'm going to turn it over to you to take us through some of that. I appreciate you being here this morning.
Sure. Thanks so much for having me. And I'll skip ahead to the question on everybody's mind is what exactly did the president do over the weekend? And was it constitutional or can it be enforced? So I will only speak to the eviction portion of this, of his executive order. But I'm calling his executive order a study, basically, because he did not extend the moratorium. What he did was ask that several agencies, HHS, HUD, Treasury, FHFA, that they all look at whether or not a moratorium is needed to continue on during this crisis to keep people safe, and if so, to use existing authority within each individual agency to implement that. He then went on to urge HUD and Treasury to use, quote, available funds, excuse me, to help make missed rental payments. The problem is no one's sure what those available funds are that he's referring to, and there were no specifics given as to who gets the funds, how do you apply for the funds, and nor was there given any effective or end date to this program, so to his study. So we'll have to wait and see what Treasury and HUD start to talk about in the coming days with regards to any extended moratorium. Before the talks broke down in Washington, excuse me, before the talks broke down in Washington last week, though, we do know NAR was working very hard on finding some housing relief efforts, knowing that a moratorium or an extension of a moratorium was likely in anything that was done. They were also looking and trying to come up with a plan to get relief for landlords, financial relief, not just forbearance relief. So monies that could go to landlords to pay off back rents by tenants. So they are working on that angle at the federal level, and we are continuing to work on that angle at the state level. There is a program that the governor is going to put in place with some federal assistance money that he is working through the details and specifics of that right now. We're working with his office to figure out how that will be best run. We are also working on House Bill 1200, which when the General Assembly comes back September 1st and 2nd and 3rd, we are hoping they will enact this legislation, which would provide, currently as as it reads, $200 million, with $100 million of that going to rental assistance, slightly less than $100 million of that going to mortgage assistance, and then the remainder going to utilities assistance. So we're still working out details there, but that is something we are working very hard on right now with our house sponsors and a large stakeholder group. That money would go directly to the landlords, and by landlords, it would be able to go through the property management companies. We made sure that that was part of the language. And we also are trying to make it very easy for the landlords to be the ones to be able to apply for the assistance, so that if you have more than one renter, you can go to the Housing Finance Agency, which would house this fund, and say, I've got here my renters, here's all the information you need on them, and here's how much they owe. And they would be able to determine whether or not that renter qualifies for the assistance, and then be able to pay you in one check rather than having to pay you individually over and over again. So we're trying to make the process as streamlined as possible as we work through the details, and hope to have something ready to go on that whenever they come back in September. The other thing I wanted to point out is there are local agencies that are helping with tenants who are not able to pay their rents. And we're meeting with some other stakeholders today to find out more about these community programs, so we can help educate all of you, so you can help educate your tenants whenever they are in financial straits about places that they can go to seek some assistance, so that you're getting paid, they're getting their rents paid, and everybody is able to continue on as is. Because I know for most of your clients, they were probably pretty good on time payers, or at least within the 5 days. And this crisis has taken us all by storm, and with the removal of the $600 additional unemployment benefits, you're likely going to see more and more of that, more and more people unable to pay. So we were trying to get ahead of this. Unfortunately, couldn't get it done before they left in June, but hopefully we'll get it done early part of next month.
Katie, thank you so much. That I think a lot of property managers, I know I've heard from colleagues throughout the state, that are seeing already for August a change in what we were seeing earlier. Several, especially in the single family sector, several of us were pretty consistent in collections for the last several months. And I'm quite sure a lot of that had to do with the additional $600. Now that that has stopped, I've heard from several colleagues that August, while still not, totally detrimental yet, I have noticed from other folks, and even in our own firm, just a slight bit, but we have noticed a little bit more of a change in August than we've seen over the last few months with respect to rental collections. So it'll be interesting to see how that plays out. And I know you have been working nonstop, all of you have, on trying to get these things done. So we'll look forward to hopefully getting some resolution to that in September. One question I did have as it pertains to that, you may or may not know the answer to this yet. I love the fact that landlords are the ones that can apply for this, so that the payments can go to landlords or PMs directly. Are the property managers able to apply on the landlord's behalf in the way that it'll work?
That is the way we are. Currently, the language is drafted so that the property manager could act as the landlord for all situations.
Okay, thank you for that clarification. Next thing that we're going to do here is our panelists have gone through a series of scenarios and questions that they've heard from folks in the industry. And so we're going to move in that direction. Amy will direct us towards the end. So if you have questions as we're going along, and I know many of you do, if we cannot get to all of your questions during this webinar, we will most certainly, Amy will make her information available. You can email Amy directly so that you can get your questions answered. But we want to make sure that we keep as much information that we've already been receiving on track, so that most of your questions will probably get answered in the realm of the next series of questions that we're going to go through here. So some of the most common questions that we've gotten, and all three of our panelists are going to help shed some light on the various scenarios that we're getting ready to go through. One, with respect to evictions. And Will, thank you for putting a lot of this together, because I know many of these questions have come through to you. And so the first fact that you have been experiencing, and we say fact, you've had folks request the tenant has failed to pay rent in June or July, but the tenant pays rent in August. There is a federally backed mortgage on the property, and it's a single family home. The question is, may the landlord terminate the lease now based on the tenant's non-payment of June and July rent?
Fred, do you want to take that one since it involves, I think this is really a CARES Act property since there's a federally backed mortgage on it.
Sure, that's no problem. So in this scenario, the tenant doesn't pay June or July, which if you remember in the CARES Act, the moratorium is between March 27th and July 24th. So we're within that moratorium period. But then the tenant comes in and pays August rent. So now I guess we're assuming we're in the month of August that they've paid their August rent. It's a federally backed mortgage on the property, so it is under the purview of the CARES Act. It's a single family home, so there's no forbearance issues going on. Can the landlord terminate the lease now? Well, you're in August, you can't just terminate the lease, but at this point, because the moratorium ended on July 24th, the landlord can now give a notice to vacate, and that must go for 30 days from the date that the tenant is given. So when the tenant receives that, it's 30 days, and then you may proceed with the eviction filing, again, under the federal standard, but there may be a wrinkle depending on, under the state standard with Governor Cooper's order.
Katie or Will, do you have anything to add to that?
No, I think we've got a question a little later on that probes the limitations on evictions based on the state order. So I'll just hold off on that until we get to that question.
So number 2, same facts as above, where the tenant fails to pay in June or July. Tenant does pay for August. We have a federally backed mortgage on the property. It's a single family home. Except in addition to non-payment of June and July's rent, the tenant now has also failed to pay August. May the landlord terminate the lease now based on the tenant's non-payment of August rent?
So again, since we're talking about being in August, which is after the July 24th end of the moratorium, and this is a federally backed mortgage, so you're under the purview of the CARES Act. Yes, at that time, the landlord could then issue the 30 days notice to vacate, and then at the culmination of the 30 days, then file an action for possession of the property.
So essentially at this point, with this particular scenario, 30-day notice needs to be given. At the end of at the expiration of the 30-day notice provision, if the tenant does not voluntarily leave, then they are able to file summary ejectment at that point. Perfect.
No. Now I'm confused, I think. Fred, are you suggesting that you need to give the 30-day notice before you can terminate for non-payment of the August rent?
I apologize. Thanks for pointing that out, Will. That is, I'm looking at all of the rents if you're going for June, July, and August. But if just under August rent, that's correct. Since it is outside of the moratorium period, then it would not apply to the CARES Act. So you would be able to proceed as normal. Thanks, Will.
Yeah, sure thing. One reason I mentioned that is because there was a memorandum that went out from the Administrative Office of the Courts on July 24th, addressed to all the magistrates, district court judges, and the clerks of Superior Court. And it addressed several of these things, and I'm sure we could make that available somehow to everybody who's participating on this call, because say it went out to all the magistrates, and among other things, the AOC very clearly states that since the moratorium has expired, that if August rent, you could terminate just based on whatever notice the lease requires. But you couldn't probably go after the June or July rent, you know, using our hypothetical. Interesting question, but it's questionable whether or not you'd be able to get a magistrate to award you June or July rent because of the, you know, that did fall due during the moratorium period, and you would have to give the 30-day notice, as Fred said. So if you want possession and are willing to give up on the rent, this may be an option for you.
One of the things that that our firm is actually doing, and I know I've chatted with the three of you about this last week, and this may be something that may be helpful to our membership and to other property managers across the state. It's going to be a while before your day in court, now that you are able to file, when you get to that point in time, if you have owners that do want you to go ahead and file eviction. And so we have contacted all of our homeowners who are in a situation where the 30-day notice is going out and we're to a point where summary ejectment may be imminent. It will be several months likely before those things get caught up and you have your day. So we have been talking with our homeowners and talking with our residents that are in these challenged situations and we're sending out the 30-day notice. But during that period of time, we're also trying to talk to the resident to try to help them avoid this blemish on their record of having an eviction, which is only going to make it more difficult for them down the road to rent again. So we have homeowners that are willing to give them 30 days essentially to get out. And to our clients that we've talked to, and there's only a few so far, they are more willing to just say, look, let them have the 30 days to get themselves in a position where they can move out, and none of us want to go through the eviction process. We're trying to negotiate some of these. It's a benefit, and our 30-day notice provision has gone out, so we're in compliance there. So if we do have to file, we are in a position where we can, so we're serving our clients still properly, but we're trying to do maybe some negotiation to where we can allow a resident to leave without this eviction on their record and get possession of the property back. Because right now, depending on how far behind the residents are, most of these residents are not going to be able to get caught up if they're several months behind, and depending on their circumstances. And most eviction cases in general, you want possession back of the property. So that's one of the things I wanted to share, because that's something we've been working through on a case-by-case basis with both our clients and the residents that might be behind right now, that might be facing the summary ejectment process. So we're going to go ahead then and move on. So situation number 3, the tenant has failed to pay rent in June or July. On July 31st, the landlord gives the tenant the 30-day notice to vacate. There's a federally backed mortgage on the property, which has 5 or more dwelling units. The question is, may the landlord file an eviction action on September 1 if the tenant fails to pay the June and July rent?
So again, here you're dealing with the period for June and July rent, which is during the moratorium period, which ended July 24th. But this landlord seems to have read the CARES Act and knows that it could not give a notice to vacate during that period and waited until July 31st, which was proper. Although it has to do with 5 or more dwellings, then it doesn't say that there was a forbearance period given, that the landlord sought forbearance. So if the landlord did not, and there's no forbearance period, then on September 1st, after that expiration of the 30-day notice, then the landlord could proceed with evicting the tenant.
Will, anything to add to that?
No, just, and if there weren't, and if the landlord was in a forbearance with the lender, they would not be able to file that eviction on September 1, right?
That's correct. If it's during the forbearance period, you cannot even issue the notice to vacate during the forbearance period. You have to wait for that forbearance period to expire before you issue the notice and then wait the 30 days and then file the proceeding.
So as property managers, we really need to make sure we're doing a good job of talking with our clients to make sure people are not in the forbearance period. So we've got our rules that we need to follow, but one thing I want to make sure our members and anybody doing property management understands is you've got to make sure you're communicating with your clients to know what they've done that they may not have shared with you, because if they're in the forbearance period, you've got to make sure you're following that set of rules as well. Okay, great. This is the last scenario in section 1 under our evictions segment. And this one says, if the tenant fails to pay rent in June or July, the tenant pays August rent, there is not a federally backed mortgage on the property, and it is a single family home. The question is, may the landlord terminate the lease now based on the tenant's non-payment of June and July rent?
I'll take that one, since this is, there's not a federally backed mortgage on this property. Short answer is yes, you can file an eviction action. You know, the state moratorium is long over, but it's probably not appropriate to file it based on non-payment of June and July rent. Probably just the July rent. And that's because of what I said was included in the governor's order about giving a tenant up to 6 months to pay off the June rent. So you shouldn't be going after the June rent, we don't think, if you file an eviction, whether it's under the CARES Act or not under the CARES Act. You shouldn't be seeking to recover June rent. We're estimating perhaps not any sooner than December 22nd, because the governor's, and I can't remember now how I came up with that date, but that's basically 6 months out, I think. Maybe it was the date that the order was issued, but in any event, be careful about that. That's the purpose of that question. And we're gonna probe that unpaid June rent with several more questions coming up here.
No doubt about it, because that gets a little bit tricky. And so I do think the unpaid June rent. So we've got our next few questions, as I suspect that this question number 4 under the eviction segment, being as it covers part of the CARES Act, but then our executive order, that has created a lot of questions with respect to this unpaid June rent. And so that moves us into the next segment, which is about the unpaid June rent. So we'll hop right into that. So here we're in a situation where the tenant fails to pay June rent. The tenant pays 1 month's rent in July. Question is, should rent be applied to the unpaid June rent, or is it required to be applied to the July rent?
I think probably Fred and I both need to address this question, but my view of it, this was a real question I got last week. The way the governor's order is written, my interpretation was that in that case, you know, notwithstanding, you know, your typical trust account rules that you follow, that you would apply that 1 month's rent that was paid in July to the July's rent, not the June rent. If you applied it to the June rent, you know, thereby making the July rent delinquent, you know, that might be, and tried to, you know, evict or collect late fees on the July rent, and possibly try to evict the tenant for non-payment of the July rent. That could be seen as a way to try to dodge the governor's order. Our recommendation is that you apply that unpaid rent to July and leave June unpaid on your records unless and until you're actually able to collect it.
And I would agree with Will. I think for a trust account perspective, it's a little bit different. Make a notation of it. So if, you know, you can explain to the auditors, this was during the period of time, but I think the purpose of the governor's order was to assist tenants who could not afford to make those payments due to the pandemic. And so if a tenant is coming in July with only one payment for June and July, it's reasonable to assume that they can't make July's payment for those circumstances. So you would apply it to July, and under the order, they have that time frame to make the payment in June.
Okay, thank you for taking us through that. That definitely creates a level of complexity, but it's good for us to know. So to clarify, we want to make sure that the PMs know if you have unpaid rent for June and the tenant does pay July rent, you are not going to apply that towards the June, unless the tenant directs you otherwise. You cannot apply that to June rent. You're going to apply that to July rent. So June will remain unpaid. Okay. So that brings us to another scenario where same scenario where tenant fails to pay June rent, but the tenant notifies the landlord of their decision to terminate the lease on July 31st. The tenant does pay the 1 month rent for July, but June remains unpaid. They're ending the lease on July 31st. May the landlord apply the tenant's security deposit, the lease is terminating, to the unpaid June rent? So Fred, I'm gonna let you start with this one, because in the terms of what we normally do, of course, we're not in normal times right now. Property managers are able to take the security deposit and apply it to unpaid rents. So the question is, the lease is now terminating. Can we process the security deposit in the same manner that we would if things weren't in COVID?
And that's a very good question, because the governor's order regarding the evictions deal with only that. It doesn't mention the Tenant Security Deposit Act. And under the Tenant Security Deposit Act, a landlord can use a tenant security deposit for unpaid rent. And in this case, I think especially if you have a tenant that's at the expiration of their lease and they're voluntarily leaving, we're not dealing with an eviction, then I think you can do that under the Tenant Security Deposit Act and use the TSD for the unpaid rent of June.
Katie, do you have, I know you had shared some information last week. I think you were in agreement on that interpretation, that our firm has actually been processing in that manner. To Fred's point, we're not in an eviction situation. The lease is terminating. They're voluntarily leaving. So we have been processing security deposits within that same realm of being able to reconcile the way we normally would. Do you feel the same in that capacity?
I do, because this executive order was solely meant to address keeping people in their homes if they wanted to stay in those homes. It was not addressing people moving on or moving out.
This one actually, I think for property managers is probably good news to hear, because the rest of it is getting so confusing. Will, I'm assuming with respect to this one, we have said that this is pertaining to, the executive orders have been pertaining to people staying in their homes. So I'm guessing after our conversations and things last week, do you have a difference of opinion on how that can be processed, or are you in agreement there?
Yeah, I'm sort of torn on this one. I certainly think that Fred and Katie's position is a well-reasoned one, in that if you applied the security deposit to that unpaid June rent and the tenant said you can't do that, that you've got a sound basis for your decision, and it'll probably be okay. But I will say that there's certainly an argument that can be made that the effect of applying that security deposit to the unpaid June rent is really effectively denying the tenant the opportunity to pay that June rent over a 6-month period of time. So the argument's there to be made, and maybe how you address it is going to be to an extent dependent on your risk profile. If this is something that will be worrisome to you and might cause you to wake up in the middle of the night, and lose sleep over it, maybe you want to go a more conservative route and not apply it to the June rent. But if you're willing to, I don't want, maybe risk is a little bit strong word, but if you think, well, what they're saying makes sense. I mean, this really doesn't. This is addressing a different situation. You've got a tenant voluntarily leaving. But how about what if the landlord were the one terminating the lease? At its natural end, would that make a difference in your analysis? Maybe it shouldn't, I guess, but I do wonder. But again, I don't want to be a wet blanket. I think it's appropriate for you all, if you choose to do so, to to dock the security deposit for that June rent. And maybe practically speaking, the worst thing that can happen is if the tenant really pushes back hard on you, you might reconsider or something. But anyway, sorry to throw some smoke into the ring here on this question, but
you bring up a good point, Will. What if the landlord is the one terminating the lease? Then the person is not leaving the house, maybe voluntarily. The lease just happens to be up, and so that could create a fact pattern in which a court might say they should have had 6 months to pay that back rent because you were effectively making them leave the property. So I think the fact pattern will always have a part to play in whether or not you should use that June rent. I also think this is what happens whenever people aren't consulted when, drafting executive orders that are well-intentioned, but not necessarily completely thought out. And so all fact patterns can't be addressed in all laws. And so it really is just a matter of each individual fact pattern.
This was the most difficult question that we grappled with when we were doing a planning meeting for this presentation on Friday. This was the hardest one that we were trying to deal with.
So one, I suspect your phone's going to ring even more now as people's leases are starting to expire. But same sort of question that has come up. If someone, let's say the tenant is voluntarily leaving their lease, they owe more than just June. They may owe months prior to June. In an instance where the tenant is, same type of question, but they owe more than just June, whether the tenant or the owner is terminating that lease, notwithstanding June, are you able to reconcile the deposit in the normal manner in taking monies to give to the owner when you reconcile for past due unpaid rents?
Other than June?
Mm-hmm.
Yeah, I would say so.
Okay, good. Seems like we're all in agreement on that one. The June one gets a little bit sticky, so I think PMs probably need to err on the side of caution and really pay attention. Who is terminating the lease? Is it the tenant or is it the owner? And there may be a situation where the owner gave notice to vacate, but the tenant is okay with it ending because they won't have this eviction against them and things like that. So maybe it can get worked out. But in that situation where the owner is terminating, the client is terminating, it's probably best to err on the side of caution, it sounds like, versus just automatically assuming you can reconcile that June when it's the client that terminated and not the tenant.
And I don't know, Jennifer, if there's a way, we mentioned this memorandum from AOC that came out from their legal counsel regarding some of the CARES Act and that sort of thing. And I don't know if there's a way that NC Realtors could ask for their opinion on that type of scenario as well. What would they instruct their magistrates to do in that scenario? Because that's ultimately going to be the arbiter of this. When the landlords or the property managers go before, it's going to be the magistrate's determination.
Yep, that's a great point. Katie, can we work with you and Amy to maybe get some kind of an opinion about that?
I can't promise a quick turnaround, but I can certainly make the request.
Okay. Thank you. So that takes us to, it looks like right now, sort of our final scenario. This one's a little bit longer. So we have a scenario where the tenant fails to pay June rent. The tenant pays 1 month's rent in July. The landlord applies the payment to July rent, and the landlord emails the tenant offering the tenant the opportunity to pay the June rent in 6 installments beginning August 1st. The tenant fails to respond to the landlord's offer. The landlord makes the same offer again by email, and the tenant again fails to respond. The question is, may the landlord terminate the lease and file an eviction based on the tenant's failure to pay the June rent and to not respond to the landlord's request?
I drafted this question just to get at the point of, does the governor's order, is it read in a way that the tenant has to ask for an accommodation, or you just have to give it? And it doesn't say that the tenant has to ask for the accommodation. And so, my interpretation is that you've got to offer it to the tenant really probably at any time. I've even seen a hypothetical question in another Q&A put together by another association that suggests that even if the tenant showed up at the summary ejectment hearing, if you played this fact pattern out and you're at the hearing and you're trying to recover possession for the non-payment of that June rent, that they never sought an accommodation to pay, that if they asked at the summary ejectment hearing, you'd have to give it to them. So that's the only point we were trying to make with this last question.
Now, I appreciate that, because that's very valid. In a lot of instances, when tenants don't respond, again, under normal circumstances, and I don't know that normal is going to look different from what it does today when this is even over. There may be a lot of things that change the way property management is done to some degree on a permanent basis, some for the good and some not. But this does make the point of the order was issued that they have up to 6 months to pay this June rent. And therefore, whether or not the tenant responds to your request as to how they'd like to work that payment arrangement out doesn't mean that if they don't respond to you, you can move forward against them with respect to June rent. If I understood correctly, you're letting us know, err on the side of caution. They don't necessarily have to ask for it. It was already given to them. That takes us through, I want to leave some room. I'm going to turn it back over. I cannot thank the three of you enough. And I know we've talked about as things continue to move forward, because there are still so many unknowns. I know, Katie, you all are working through between rental assistance and is this moratorium going to get extended? At this moment in time, it has not been, but that's not out of the realm of possibilities. And if so, it could be towards the end of the year before that changes. From what I'm seeing, it's kind of like a 50-50. Some days it looks like a moratorium is going to come back, and other days you're like, I'm not quite sure. So obviously, as we continue to work through these things within our state, with the three of you, I know you have all said that you're willing, as we get more information and things become more available and change again, to hold another session like this where we can continue to help bring clarity. Because our biggest thing is we're trying to educate our members and educate our folks in our state that are doing property management, even if they're not PMD members. I think we would all agree it's critically important that we're educating the PMs within our state so that they're operating in the best manner possible in such a situation of turmoil and unknown. So I cannot thank the three of you enough. And with that being said, I'm going to turn it over to Amy. She may have some additional questions that have come through the chat for the three of you, if you don't mind. I think we have about 10 minutes left.
Yep. So thank you guys so much for clarifying a lot of confusing and ambiguous information. We really appreciate all the time you put into this. And you were so good that we don't have any questions yet. I think you covered all the ones that popped up in the chat. So I'll give everybody just a minute or so if anyone else has any questions to put those into the chat. And while you all are doing that, I'll just remind you to please use the legal hotline. I posted the email address and the number in the chat. You're welcome to send me questions, but I am an event planner, so I probably can't answer them like Will can. So I'm happy to filter those to Will, but please use that legal hotline if you have any questions anytime. That's what they're there for. And also, Will can probably put some things into the Realtor Roundup on a weekly basis, and we will definitely keep talking and do another one of these. So I don't think there are any questions.
Just real quick, this is Katie. There was a question that someone put in the chat box whenever we were talking about one of the specific fact patterns that asked about the March, April, or May rent. And so I think just to clarify, any of the discussion covers anything, any rent that was due under that moratorium period, which was for the CARES Act, March 27th through July 24th. So just using June and July as examples, but the March 27th through July 24th is what the CARES Act applies to. So just making sure folks understood that.
Okay.
Thank you, Katie.
Yep, thank you, Katie. And thank you, Jennifer, for being a great moderator, a great chair of PMD. Thanks to Rachel for setting this up.
It was easy to do. And Amy, this is going to be sent out to the association as a whole or PMD members?
Yes, well, everyone who participated in this webinar will receive a direct link to the recording. And thank you all for participating. We appreciate that you are concerned and want to know more and want to do right. And then we will also send this out probably separately to the PMD members, and then we'll send it in some format to all NC Realtor members in case they are property managers who aren't part of PMD.
Yep, I thank you so much for doing that, because while obviously there's benefits to being PMD members, this is one that I think we would all agree we want to make sure. We have several realtors that are practicing property management, and it's too important. We want to make sure we get it out to everybody. So I can't thank you enough as well for orchestrating, you and Rachel both. I hope Rachel's still here, but between the two of you, orchestrating all of this, making sure everything gets out. And then Will, Fred, and Katie, thank you so much for your expertise and all of your hard work. There's no way we could navigate through this without the three of you.
No problem.
Thank you, guys. With that, we'll just close up the meeting. I don't see any other questions. Always feel free to reach out to us, and have a great rest of your day.
Thank you. You too. Have a great week. Bye-bye.
Bye.
Bye-bye.